SJC-11169, Commonwealth versus Charles.
All right, let's proceed. Yes, sir.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court, Stephen Hochter, Assistant District Attorney from Middlesex, on behalf of the Commonwealth. Your Honors, this is a case in which this Court granted further appellate review on the limited issue of whether the defendant may be retried for possession of a loaded firearm after the same jury found him not guilty of possession of ammunition, and it was the ammunition contained within the firearm. Your Honors, the appeals court decided that based on double jeopardy and collateral estoppel grounds that the defendant could not be retried for possession of a loaded firearm. The Commonwealth respectfully disagrees with the appeals court's opinion and decision on that issue, because here we have a case where we have inconsistent verdicts by a single jury in this case, and for double jeopardy purposes, a retrial is permissible after a successful appeal from a conviction. Also, in double jeopardy law, when the courts talk about a subsequent prosecution, they're referring to a separate or independent prosecution, not a retrial. And here, this would be a retrial, obviously, in this case. And here we're not talking about the same offense here, which would be barred under double jeopardy principles. Also, with regard to the collateral estoppel basis, here collateral estoppel shouldn't bar the retrial in this case because the defendant can't satisfy the third prong of the elements of collateral estoppel, which is a showing that the determination was in his favor. Here, since we have the conviction for possession of a loaded firearm, the jury necessarily found that the firearm was loaded and the defendant possessed that ammunition contained within the firearm. So it's not a favorable result for him in the prior trial. So, Your Honors, the Commonwealth submits that based on these circumstances, here a retrial shouldn't be barred and the Commonwealth should be allowed to retry the defendant for possession of a loaded firearm. The jury here, although we have inconsistent verdicts here, the jury may have found that the jury may have compromised, I should say, and decided to find the defendant guilty of the greater offense and not the lesser offense of possession of ammunition. If the court...
Knowing that if they had convicted of both, the other would have had to have been...
I'm sorry, Your Honor?
Well, it seems under our case law that if the jury had convicted of both, the lesser would have been dismissed after the fact.
That's correct.
So I'm just making the...
So,
I mean, as though the jury knew that, but they went the other way.
so if the court has no further questions, I will rest on my brief.
Thank you.
Thank you, Your Honors.
Yes,
Good morning.
counsel.
Good morning, Your Honors. Charles Hope. I represent the defendant, Jeffson Charles, in this case. Mr. Charles stands before you acquitted of possession of ammunition. Nonetheless, the Commonwealth accuses him of possession of a loaded firearm based on the same ammunition and seeks to retry him on that charge.
Well, there's nothing wrong with these verdicts. I mean, let's assume the case wasn't reversed because of the ballistic certificate. I mean, they may be inconsistent, but they certainly are valid.
That's true, Your Honor, but that's not this case. We don't argue that if there had not been other grounds for reversing the conviction on the loaded firearm, we don't argue that the acquittal would have required that. What we do say is that the conviction on the loaded firearm has been reversed. There's no longer such a conviction, and they would have to retry him to get a new one.
Right, but the jury found him guilty of having a loaded firearm. So just as they found him not guilty of possessing ammunition, they found him guilty of carrying a firearm with that ammunition. So why do we choose your preferred argument that they acquitted as opposed to the prosecution's preferred argument, which is that they convicted.
We don't have to choose, Your Honor. That's one of the things I say in my brief. The rules of inconsistent verdicts is that both verdicts are valid. In this case, there's an acquittal. That acquittal is valid. There's no question about it. There's no question that they can't retry him on the possession of ammunition charge.
Right.
Like that's clear. The double jeopardy clause prevents it. The double jeopardy clause also prevents him from being retried on possession of a loaded firearm.
But
It's a greater included offense.
isn't it there's something very inconsistent? If the verdict is valid and if it hadn't been reversed on other grounds, even though it's inconsistent, you would agree that it would stand?
Yes, Your Honor. That's this court's rule.
So-
This court's jurisprudence is that this court does not go into whether it's clear when an inconsistent verdict is rendered that the jury has made a mistake. What that mistake is, this court doesn't consider. This court does not does not invade the provenance of the jury to determine what mistake was made. Perhaps the mistake, as Your Honor suggested, is that the jury knew that it was a lesser included offense and would get dismissed anyway, so it decided to acquit him. That seems unlikely to me, but it's possible.
Or cumulative, or piling on, or any number of fairness kinds
Or
of
any number of
consideration.
fairness considerations. It's also possible, as this court has recognized, that the jury decided to compromise and found that perhaps they were not totally convinced beyond a reasonable doubt, but they mostly believed it, and they went ahead and said, well, we mostly believe it, but we're not quite sure, so we'll give him a break on the lesser included offense. That's what the jury could have done. We don't know what the jury did. Perhaps the jury misunderstood the judge's verdict and said, the judge's instructions, and said, well, we can't convict him of possession of a loaded firearm because there's no possession of ammunition because there's no other ammunition around. There are all sorts of things the jury could have done. But this court doesn't go into those questions. This court does not examine why the jury acquitted him. This court says there was an
Why
acquittal.
doesn't that same philosophy apply to a retrial?
Well, I'm sorry, Your Honor, I don't quite understand.
The
que-
retrial on the offense of possession of a loaded firearm.
If there was a retrial, Your Honor, this court would not look into why the jury considered what the jury's rationale for acquitting or convicting on the retrial was. But there can't be a retrial because that would be a double jeopardy violation.
That's where I'm losing you.
Well, there is no conviction, Your Honor. There was a conviction. It's been invalidated. There's no dispute that the conviction was unconstitutional. Where there is no conviction, the court cannot proceed with a new trial. For instance, the Ninth Circuit case I cite in my brief, Wilson v. Cerniak, there was a hung jury on the greater included offense, but an acquittal on the lesser included offense. The Ninth Circuit said, all right, there is no conviction on the greater included offense. There's an acquittal on the lesser included offense. That requires, under the double jeopardy clause, that no further trial go forward. The Supreme Court has said, in the context of a conviction under a lesser included offense with no verdict on a greater included offense, that you can't retry them on the greater included offense in...
Does it make a difference that there was a verdict here?
I don't think it does, Your Honor.
And that would have stood, were
It
it not
would
for
have
the,
stood, yes, Your Honor. There
for
would
the
not have...
issue.
If it had stood, there would be no need for a retrial, and it would have stood.
But doesn't that distinguish it from the cases that you are citing to us, all of which did not reach verdict?
I don't think so, Your Honor. There's no verdict in this case. There is no verdict. The verdict was unconstitutional.
There was a verdict.
There
It
was a
overturned.
verdict. There was a verdict. It was returned. It has been overturned because it was unconstitutional. There is no verdict. In any event, Your Honor, in the concept, as I am understanding the Commonwealth's position, is that because that there isn't a retrial here, that this somehow is not a second jeopardy. And that's simply false. The question before this court is, can my client be tried on this issue? They will impanel a jury, they will put him before the county, they will subject him to jeopardy. That is what the double jeopardy clause forbids. If the acquittal had been a dismissal of the charge in the middle of the case on whatever grounds with prejudice, they could not have proceeded to reach a verdict. That still applies herein.
But you're, when you took this appeal, you waived your right to double jeopardy as to a particular purpose, and that was to challenge the admissibility of the evidence. You didn't, so that was you were not challenging the validity of the verdict in any other respect. So you have waived double jeopardy, at least for getting a new trial, and the Commonwealth will now have to try the whole thing, but really the error that's involved, the error that voided that judgment, is something that has absolutely nothing to do with the jury's finding of guilt beyond a reasonable doubt.
Well, I'd suggest two things, Your Honor. One is that we did challenge on multiple grounds below. We moved to suppress all the evidence and said all the evidence should have been thrown out. The appeals court did not agree with us on that, but we did move for it as part of our appeal. And the second response, Your Honor, is that to the extent that one waives one's double jeopardy right by appealing, and one does to a certain extent waive one's double jeopardy right by appealing, that's only with regard to that conviction. I agree that the fact we were convicted and then that was overturned on appeal does not mean by itself that we couldn't be retried. It does mean the double jeopardy clause has no impact on a second trial. If it meant that, this court could never state that the defendant, there was insufficient evidence and the defendant should be acquitted because you took an appeal, so they get to retry you, whether or not there's other grounds that they can't retry you. That's not the law. The law is that you waive your right to object to a retrial based on having gone through the trial that resulted in the conviction on that charge, which we acknowledge. As I make clear in my brief, that we're not arguing that the reversed conviction prevents a retrial on double jeopardy grounds. We're arguing that the acquittal of a lesser included offense prevents a trial, a second jeopardy, in this case.
All right, thank you very much.
If I could, Your Honors, two more points.
You have 13 seconds.
First,
Help
the
yourself.
appeals court did also rule on estoppel. We think that estoppel applies as well here. And I would remind the courts that the first issue in my reply brief is the Commonwealth's waiver of this issue before the appeals court. Thank you.
Thank you, sir.